Good morning, Council. I see you are both in the virtual courtroom. Ms. David, and forgive me if I mispronounced it, don't forget to take it off of mute, and we are ready to proceed.
Good morning. My name is Anna Davidi, and I represent the appellant Christopher Cerna. We are here today on appeal from an order denying Mr. Cerna relief on a motion for post-conviction relief, specifically in ineffective assistance of counsel. I'm going to go back on the history a little because I think Mr. Cerna's history is very important to the argument today before the court. Mr. Cerna was arrested immediately upon being arrested on a second-degree murder case. He was placed in a special cell at the Naples County Jail dealing with inmates that have mental health issues. He was subsequently put on 2 very strong psychotropic medications, and those medications lasted for the extent of his time up until today, where he continues to take both the Prozac and the Vesatril. He now takes it at a much higher dosage than back then. Mr. Cerna case took 4 years to
There seems to be a question about whether the drug that was required at the time to be taken twice a day had been taken, whether the morning dose had been taken at the time of the plea hearing. Could you clear that up, as it was the Prozac that was the twice daily?
Yes, sir, it was.
Administration?
Yes, sir. Yes, sir.
Was that record definitively show whether he took the morning dose? He took the evening dose of the drug that starts with a V the prior night, correct?
Yes, sir. He did take that. The Vesatril, it's called. Judge, there is still a question as to that. When Mr. Cerna took his plea before the circuit court judge, the judge did ask him in his normal course whether he was on any medication, and he quite candidly told the court that he had not taken his medication that morning. Subsequent to that, there was a document introduced in court that indicated that it was given to him at 9 a.m. in the morning. We have always contested that document. There was no live testimony. Our position is that it was done because customarily the defendants are given their medicine at 9 a.m. In Mr. Cerna's case, it was nearly impossible because he was in the holding cell for several hours before that at the county jail, where they bring in all of the defendants early in the morning waiting for their court hearings, regardless of what judge they are before. So Mr. Cerna testified that he had been in the holding cell at the actual courthouse since 8 a.m. in the morning. And
was that record the document that showed that the log that he had taken his medication at that time, was that record admitted at the hearing?
It was admitted over defense objection. It was not admitted through any doctor or anybody who actually had filled out the document. Mr. Cerna had told the court that he had not received it in the morning, and that is, the subject of contention at this hearing. We believe strongly that he did not take it. He answered the court quite candidly about that. I think that the fact that he did not take it, or perhaps he did take it and he didn't even know he had taken it, goes to the core of our argument that Mr. Cerna was mentally ill, and therefore the attorney was ineffective in taking special care when this defendant waived his constitutional right and intelligently entered into a plea of 50 years after being in a holding cell for a period to exceed 8 hours. We strongly contest that his mental health issues, which his lawyer, Ms. Shannon Brown, did admit to, were extensive, and that a lawyer, when representing a client, has a duty and an obligation to deal with the client's specific needs. The lawyer testified quite nonchalantly that she dealt with him like every other defendant. There is no way that it can be believed that a person who is on such strong medication, who these same attorneys had determined could not enter into the courtroom for several years because the evidence was so gruesome that they were afraid he'd have a major setback, could be somebody who merely by responding yes or no to customary questions asked of all defendants intelligently waived his right and entered a guilty plea.
For an ineffective assistance of counsel claim in a plea case, doesn't the prejudice prong require showing that but for the ineffective assistance of counsel, or but for the involuntariness of the plea, he would have gone to trial? He would have decided not to accept 50 years and would instead have gone to trial?
Yes, Judge, and I think that our pleading specifically—
What supports that element of your claim?
Judge, the client, when executing the motion, clearly stated that, and further, he stated it during his testimony. The morning or the afternoon where the plea was taken was supposed to be, the morning had been dedicated to motions in limine reference this case. That was the morning of the trial. That was the day that my client had always determined he was going to go to trial. Interesting enough, there was testimony by his lawyers that there was at least one, I think 2 doctors that found him insane. They had documented their intent to use insanity as a defense in this matter. So with all of these different knowledge, or the knowledge that these lawyers all had, the fact that they determined that it was appropriate to just have him answer these perfunctory questions with a yes or no answer, when they specifically heard that he had not taken his medication, they did nothing to, at this point, advise the court or tell the court, listen, here's the defendant, because the court doesn't know the history of this defendant. The prosecutor doesn't know the history of this defendant. The ally or the person who's specifically working for Mr. Serna, like all lawyers are, his representative are his attorneys. The fact that they were negligent and never advised the court list, they didn't even know what medication he was taking.
Let me ask a question. At the hearing, the evidentiary hearing, was there any testimony by his psychiatrist or a pharmacist or a doctor as to the impact, if he didn't get the medication that morning, as to what the impact of that would be?
No, Judge, there was not. The client testified and told the court that he gets hazy, his thoughts are not clear, he gets anxiety. I think he described it as being on a hamster wheel and not being able to appropriately process the thoughts.
And then
That was, go ahead, Judge.
Understanding that testimony and the testimony of the attorneys who said they did not see any difficulties that your client was having understanding them or understanding the process, and then the court reviewing the transcript of the plea hearing where the court went through everything. I mean, isn't the court entitled, in terms of weighing credibility, to say, I've got 2 different stories and I'm believing this story as far as the attorney's testimony, as opposed to you now coming in 2 years later, not having filed a motion to withdraw plea, not having taken a direct appeal of the conviction, and say, I just don't think that the medication prevented you from understanding what was happening. Isn't that a credibility determination for the trial court?
Judge, I think that, first of all, your question is twofold. I do not believe that the fact that he did not file a motion to withdraw immediately after the plea, when he was represented by these same counsels, and did not take an appeal, which would then have placed the burden on the judge to determine whether or not the client or the defendant was competent, was his only remedy. And the state seems to say he waived the remedy for challenging his attorney's credibility because he didn't take a direct appeal. But the direct appeal attacks the judge's conduct during the hearing. I believe the judge did what he was supposed to do, and left it to the attorneys, who were really the people who had the direct or the relationship with the client, whereby they had to tell the judge what was going on with this specific defendant.
That's part of my question. And I recognize that that is not preventing your client from pursuing the claim that he brought. So let's go to the second point, which is, as you said, the attorneys were in the best position to relate to the court their observations or any concerns. They didn't do so, and they explained why they didn't do so. So why is the court not entitled to make the credibility determination that it made?
Because I think, Judge, that in a case like this where oftentimes the courts find that an attorney's ineffectiveness is attributable to a strategic decision. I think in this case, the attorneys were not doctors. So while they definitely should have brought it to the court's attention and asked for him to be evaluated in some sort of competency capacity, because they claimed that they were able to now be able to speak to him continuously and that he understood. Now, I think it's important to note that this happened through a glass in a room that is no bigger than 6 by 6. I mean, these lawyers, 3 of which, what is interesting is the first lawyer specifically said he was not going to take a plea. That was much earlier in the day, as the 2 other lawyers came in.
But counsel, don't we have one of the defense counsels was, I think it was Kelly, a chief in the public defender's office. This is someone who had represented the defendant here for quite some time, right? And that person testified that to the experiences that they had with the defendant, that the defendant had the ability to understand. And so just to tag on to Judge Silverman's question, as far as credibility, the trial court is the one who gets to determine the credibility, make the credibility determinations. And so when it comes to us, isn't there we have to, so long as there's competent evidence that the trial court relied on, we get to defer to that, and there's a strong deference that we make to that. And so here we have record evidence of that. So I mean, if there's credible evidence and there's competent evidence, why should we just not affirm?
Well, because number one, Judge, I do not believe that there was competent evidence. I think that the contact between the lawyer and the client was so perfectory, or just, it did not really give him the opportunity, I think, to determine whether a person understands or doesn't understand. That comes from the client, and that also comes with the lawyer's caring.
But that's the credibility determination, where the court in this instance made credibility determinants in favor of the defendant's counsel, and certainly has the right to find the defendant not credible, right?
Yes, ma'am. And I think that the court incorrectly viewed the testimony of the lawyers as credible, and I think that that is something that this court can view when they consider the surrounding circumstances of this specific defendant. I think that the fact that he was treated by his main counsel, who is Miss Shannon Brown, as if he was just any other defendant, creates a belief that he wasn't treated with a special care. And what I think is that attorney has an ultimate responsibility to treat each client as an individual, and to say, I explain it to everybody, and as long as they say, okay, that is sufficient to me. I do not believe that that is sufficient. I believe.
How are we supposed to know whether or not it was sufficient, years and years later now?
Well,
and you say it's because we should believe the defendant now, as opposed to believing the defendant on the morning when there was a plea colloquy that was on the record seemed perfectly fine, because he didn't take his Prozac in the morning. But how are we supposed to determine now that it was insufficient?
Before I answer that, I wanted to reserve 5 minutes for rebuttal, and I don't know if I did that, and I apologize.
I believe you did, but either way, you've got about 45 seconds left till you reach that point.
Okay, so I'm going to talk very quickly. I think that if the court considers the facts of this case, and I understand the plea colloquy said, you're asking a person with mental health issues who has issues in understanding perfunctory questions, and the client can say yes or no. How is the court supposed to determine that? They're supposed to be told the history of the client. The lawyers are supposed to take special care in saying, hey, this client has special issues. We didn't even bring him to court for a certain period of time. He is taking all of these medication. Competency was definitely an issue in this case. They asked for a competency issue. They asked for a competency request, and then subsequent to that withdrew that. So competency was always an issue with this defendant. And while there's no specific standard that I believe can apply to each defendant, I think we have to take each individual's characteristics. And I think it's the lawyer's obligation. It's just not accurate or not correct to tell the defendant, well, okay, he went through the yes, no, yes, no, yes, no, said I didn't take my medication, and that's sufficient.
And just let you know you're at your rebuttal time if you wish to reserve it, or you can use it.
No, I'm going to reserve it at this point if there's any, and I'll respond afterwards. I appreciate it. Thank you.
Thank you very much. And counsel for the state, are you ready? We're ready for you.
Yes, Your Honor. Thank you very much. Good morning. My name is Nina Sharrock, and I represent the state in this matter. As the court can see, this is an appeal of a motion for post-conviction relief filed pursuant to 3.850 or 3850, in which the trial court held an evidentiary hearing on one issue, ground one, and subsequently entered an order denying both issues. As the court can see from the state's briefing, the state believes that the threshold issue in this matter is preservation. Neither of these issues were preserved for this court's review. The appellant cannot raise issues that do not comport with the issues raised in his Rule 3850 motion, and then subsequently raise new issues on appeal. Excuse me. Specifically, in issue one, on appeal, the appellant argues that trial counsel rendered ineffective assistance for allowing him to enter his plea despite the time frame in which he was given to consider the plea and in light of his mental health issues. However, in his 3850 motion, the appellant argues trial counsel rendered ineffective assistance for allowing him to enter his plea despite knowing that he had not received his medication that day. Those issues, while similar, are not the same. They do not comport with one another, and this court should not allow this appellant to raise a new issue on appeal that was not raised in the 3850 motion below. There was no mention of the time frame in which this appellant was given to consider the plea in the 3850 motion. Similarly, as to issue two, on appeal, the appellant argues that trial counsel pressured him to accept the state's plea offer and enlisted his family members to also pressure him to enter into this plea agreement. In his 3850 motion, the appellant argues that trial counsel rendered ineffective assistance for failing to pursue and present an insanity defense. As the court can see, these issues are not at all the same. They are completely dissimilar, and there was no mention of any pressure on this appellant to accept the state's plea offer in his 3850 motion. And of course, unsurprisingly, the trial court did not enter written findings as to any pressure on this appellant to enter his plea because the appellant didn't raise it in his 3850 motion. Further, there was no mention of the time frame in which this appellant was given to consider the plea in his 3850 motion. So the trial court, unsurprisingly again, did not enter a written finding regarding the time frame. And the state would argue that arguably, because this appellant has not raised the two issues raised in his 3850 motion, that he has waived consideration of those two issues on appeal. And I would actually like to clarify something first that the court asked the appellant about the medication log. It was actually entered into evidence during the evidentiary hearing as a joint exhibit 1. And that is found at the record at page 423. So that exhibit was entered jointly. So I just wanted to clarify that. And moreover, the state would argue that even if these two issues that the appellant has raised on appeal were preserved, they still fail. And the reason is because the trial court found very credible the consistent testimony of all three of the appellant's trial counsels. All three of the appellant's attorneys testified that they observed the appellant during the discussions with him regarding the plea. They didn't think that he was suffering from any mental infirmity or having any issue understanding what they were saying. They didn't think that he lacked an understanding of the plea offer that was conveyed to them, or that they had conveyed to him rather. And the trial court credited the testimony of the appellant's 3 trial lawyers. And this court is entitled to rely on those credibility determinations and should in fact give it deference. This court is not permitted to reweigh the credibility determinations that the trial court made regarding the credibility of the testimony that was presented to it during the evidentiary hearing. And further, based on finding the trial counsel's testimony credible, the trial court was implicitly finding that the appellant's testimony lacked credibility because it was contrary to the 3 attorneys' testimony. And again, this court should give great deference to the trial court's findings in that respect. Furthermore, the trial court conducted a very thorough plea colloquy with the appellant at the time that he was entering his plea. The appellant indicated that he had understood everything that had gone on that day. He had no questions for the court or for his attorneys, and that even though he had not had his medication, that lack of medication did not affect his ability to understand. And this court should not allow the appellant to go behind his previous sworn testimony and now claim to the contrary. And as to the claim that the appellant just simply answered yes to every single question, the state would point the court to the plea colloquy at pages 6 and 8, where the appellant actually asked clarifying questions to the court and didn't just simply answer yes. I think that evidence refutes any claim that the appellant was simply told to go into court and say yes to every single question. And moreover, as the court asked the appellant on their questioning, the standard is for prejudice, the appellant must show under Hill v. Lockhart that he would have foregone this plea and gone to trial, but for any alleged ineffective assistance by his counsel. And the state doesn't believe that the appellant can show prejudice in this case. As the court can see from the record, the trial court held a very lengthy motions hearing the morning that the appellant entered his plea, during which the court discussed probably about 100 photos that the state intended to offer at trial if this appellant decided to go to trial that Monday. The plea was entered on a Friday. By all accounts of the photos, they were extremely gruesome, very inflammatory, and so much so that the defense sought to keep out every single one of these photos from the jury's view. The trial court ended up ruling that the state could present about 75 of those photos. The photos depicted about 125 stab wounds that this appellant inflicted on his victim, her decapitated head at his hands, and her head impaled with a rod, in addition to numerous defensive wounds showing that the victim tried to fight back but was ultimately unsuccessful. So in light of that fact, and the fact that the appellant was planning on pursuing an insanity defense on that Monday, which is an implicit confession to this murder, and if the jury decided to discredit that defense, they would have been armed with a confession to this murder when they went back to the jury room to deliberate. So the jury would have been armed with a confession to consider, as well as 75 extremely gruesome photos of the heinous acts that this appellant committed against this victim. And so based on those 2 facts and the totality of the circumstances of the case, the state does not believe that this appellant would have foregone this plea and decided to go to trial. And I would also like to note that while competency was not an issue at the time of the plea, Shannon Brown Hurst testified during the evidentiary hearing that she did not believe that competency was an issue, and that initially, if she had thought that competency was an issue, she would have revisited the issue, but she did not. And the trial court again found her testimony credible, and this court should find the same. And I'm prepared to answer any questions that this court has regarding the merits of issues 1 and 2 on appeal, if there are any.
Very good. Thank you very much, counsel.
Right. I apologize, Your Honor. I would just like to emphasize the state would ask that the court find that issues 1 and 2 are not preserved, but if they were preserved, then they still lack merit, and the state would ask that the court affirm.
Very good. Thank you very much. Counsel?
Thank you.
Yes, sir. Ma'am, the defense's position is, and I think it's maybe a little misconstrued by the state. What we did, Judge, is we did not argue in our appeal the second issue of whether or not they preserved or waived their insanity plea. What we did was we rephrased our issue in issue number 1 and number 2 of the appeal. It's not correct to say that our second issue doesn't match our second issue in the motion for post-conviction relief, because it shouldn't. It is part and parcel of the first argument that has always been that he was not effectively represented during his plea. First, because he said he didn't take the medication, and second, because he didn't intelligently waive his rights. If Your Honor looks further at not only the label or the title of the issue, but looks at the brief that we gave the lower court, the reply brief that was given to them, and the arguments to the court, it was clear that the issue of the evidentiary hearing dealt with whether or not this defendant waived his right intelligently because of his extensive mental health issues. So I do believe that the issues have been preserved. Second of all,
Yeah. That's pretty general. Isn't there plenty of case law that says the specific argument, not just the specific claim, but the specific arguments you raise in the trial court must be the ones raised on appeal, as opposed to alternative arguments not brought before the trial court?
yes, sir. And I believe that the arguments that we gave the lower court are consistent overall with what was argued in the appellate court. While we may have renamed them and named them separately and separated them, we definitely always have argued extensively during the evidentiary hearing, during our reply brief, during the different motions that were filed before the court, that the defendant's mental health issues attributed to his inability to take a plea in this case intelligently, and that his rights were violated. Twofold, especially because he didn't take his medication. While I understand, and now I look back at the record, it was jointly introduced, all of the records, because I think the records also confirm that he was taking the 2 medicines. We have always challenged what that document said, based on the testimony of the client that morning and the inability of him to have taken that medication at 9 a.m. in the morning. So I think the issues are clearly preserved. We have waived our second issue at the trial court level having to do with the insanity defense. But the first issue, which is now divided up into 2 separate subsections, is clearly preserved. I believe also that the fact that the defendant was asked questions and basically said, I did not take my medication, is important for the court to note. The court can always, that is why they're the appellate court, they're the courts that are reviewing what goes on in the lower court, can always review.
We understand what our role is, counsel. Thank you.
Okay, I apologize. Additionally, Judge, I think that the fact that the state has argued that the lower court had decided that morning that 75 gruesome pictures should be allowed in should actually play no part in any court's decision, because those pictures are consistent with the insanity defense. The client gave a full confession. The client was well aware of what he told the police when he was arrested, and there has never been an issue as to the fact that the insanity offense was going to be presented by this defendant. So much so that they had lawyers, that they had doctors that had been hired by that had been allowed to be hired by the court to evaluate this defendant. And I think the prejudice is clear. The defendant had always maintained his right to go to trial. The defendant wanted to go to trial. He had spoken to his attorneys about it. The defense lawyer specifically said that they had talked about going to trial and that he knew the aspects of the trial, and he had always said, I want to go to trial. I want to challenge it based on the insanity defense. Completely different from the testimony that his prior lawyer gave regarding her going over his rights that he was waiving that morning. She specifically said she doesn't remember if she went over with him what the rights were in a written document. She just remembers going over them like she does every time with every defendant. And
Yeah. Time has concluded. Take 15 seconds to wrap up.
yes, in closing, I ask that you determine that the client's petition and appeal for ineffective assistance of counsel has merit, and that it be returned to the lower court and allow Mr. Senra to have a new trial. And I thank you for your time.
Very good. Thank you both very much.
Thank you.
Thank you. Have a wonderful day.
Case, and the next case is Zurich American Insurance versus Sampson.